petition one case from the list notes. Item number 6 in the supplementary list notes. Yes. For this is CMP with defect notes filing number notes. It is for restoration of a writ petition.
क्या करें हम? Restoration is not an urgent matter.
Do not urgency ये note में writ में there was an interim order because of dismiss for default note. अब डिलीवरी ऑपोजिशन वाला CMP फाइल
मूव करिए.
जो डिफेक्ट के लिए आईए फाइल किए हो जो डिफेक्ट है कि पिटीशन नंबर 1 पार्टी नहीं है उसके लिए आईए फाइल किए उनका डेथ हो गया तो उसको पार्टी नहीं बना सकते वही पॉइंट ऑफ व्यू आईए फाइल करो कोई भी टाइम नोट खाली टेक अप करके रखा है
आज कैसे टेक अप हो जाएगा भाई इतना अर्जेंसी नहीं है इतना अर्जेंसी रहता तो आपको डेट में नहीं
नोट डिलीवरी ऑपोजिशन के लिए
कुछ नहीं
वहां दखल देना नहीं चला गया
इतना भी अर्जेंसी डिफेक्टिव मैटर्स में नहीं है
और डिफेक्ट हम रिमूव नहीं कर सकते हम आईए तो हो सकता है वो फाइल कर
इतना भी नहीं है ना आप इस तरह से नहीं होता
और इसमें खाली डिफेक्ट इग्नोर होते हैं लोग क्योंकि आईए जो फाइल किया है उसमें लोग क्या एडवाइस वही होगा कि हां पिटीशन नंबर 1 एक्सपायर कर गया
बिना नोटिस के तो हम कुछ ऑर्डर
हां नोटिस हम वही बोल रहे हैं कि आईए खाली डिफेक्ट इग्नोर हो जाएगा इसलिए हम आईए फाइल किया और नोटिस होगा
किसका डेथ हो गया
पिटीशन हां
ओनली पिटीशन
4 पिटीशन थे तो डिफेक्ट लगाई पिटीशन नंबर 1 जो है सीएमपी में पार्टी गई हम लिखे कि पिटीशन नंबर 1 का डेथ हो गया है और इसलिए आईए फाइल
इट विल कम हम लोग का सीएमपी का डेट फिक्स्ड है ना फ्राइडे को रहता है फ्राइडे को है
ठीक है फ्राइडे को ही लग गया बट आज नेशनल फ्राइडे को लग गया टेक माय टाइम
कितना आप बहस करते हैं आपको बोल तो दिए एक ही चीज नहीं समझ में आ रहा बाकी कोई डिफेक्ट नहीं है ना
नहीं बाकी कोई डिफेक्ट
होगा तो मत लगाइए
पर दो डिफेक्ट है दोनों के लिए आईए फाइल
आज का लिस्ट है
आज के लिस्ट
सप्लीमेंट्री लिस्ट
इसे तो बोल रहे हैं टेक अप हो जाता कोई भी
मतलब ये सीएमपी है ना फ्राइडे के अलावा किसी दिन मत लिस्ट किया करिए कोई भी स्लिप फ्राइडे से पहले मत कराओ 4 बजे
From supplementary list, I am writing for final disposal item 1, second appeal 182 of 1999. 1.
On behalf of grant number 4, I have to submit something. In this case, I am a bona fide purchaser. I have been driving in this. What happened in this case on 30/9/1977? Its power of attorney was executed by defendant number 1 in favor of defendant number 3. On 30/9/1977. This power of attorney is Exhibit A. It is a registered document.
Exhibit A.
It is a registered document
by defendant number 1 in favor of
defendant number 3. On the ground, because of his old age and other factors executed by this power of attorney in favor of number 3 for transferring the management and all his legal responsibilities as well as CBA. Then on 20/8/1982, on the strength of that power of attorney, defendant number 3 entered into an agreement with defendant number 2 for sale and transfer of the on consideration. That sale was that agreement is exhibited on the record. Then on 20/12/1982, defendant number 3 executed sale deed in favor of defendant number 2. In the meantime, the plaintiff has filed issue.
इसमें कल का डिक्टेशन कहाँ रखे हैं आया होगा घर से
In the meantime, plaintiff has filed issue.
Well.
13/12/1982. And stating therein that on 18/9/1982, the principal, defendant number 1, had entered into an agreement for sale of the suit premises with him.
Strength of agreement dated
89/82. It is exhibit 3. So my agreement was earlier than the plaintiff.
ये तो आप कल बहस कर चुके हैं, रिपीट क्यों कर?
Then
Why are you repeating it? ये तो कल आप बहस कर चुके हैं. Yes. ये क्या फिर से रीहियरिंग हो रहा है? फिर कोई नया बात बोलना है तो बोलिए, रिपीट मत करिए. कल पूरा दिन आपको सुने हैं.
then two were contested. Defendant number 1 has not filed his written statement.
Defendant number 1.
Yes. He has not filed.
Yes, it is there. It is there in the order. He pointed it out. He pointed it out that the case has to be decided. Admission से नहीं चलेगा.
Then in the suit, the defendant number 3 has filed. 3 and 2 has filed.
तूने फाइल किया.
2 has filed. He has stated that on the assent of that power of attorney, number 3 has executed sending in my favor, and on payment of consideration amount it was sending was executed, which is exhibit G on the record, and on the basis of that sending he got the defendant number 2 has got his name written in the office of municipal corporation, that is exhibit F order of commutation, and exhibit D and E are rent receipts. Instead, I have pointed out that on the point of readiness and unwillingness, the other appellants have argued. But my submission is that readiness and willingness is to be proved by their conduct. So, you,
This was also argued.
yes, I have argued.
This was also argued yesterday. That readiness and willingness has to be proved by conduct. A citation was also given. on this.
And there is one more citation which is reported in 2023 Elections Supreme Court cases 775 UN Islamic disease.
दीजिए जजमेंट दीजिए. Which para?
It is para 26 continuous from the date of agreement. Then mere filing of the suit is mere design. I have argued yesterday that when the suit was filed, it was filed with the copy of rupees 1.5.
सर रिपीट मत करिए. आपका एक एक शब्द हम नोट किए. Please do not repeat and don't waste my time. Otherwise, I will just stop you from arguing.
So para 26 and 30 are there.
That's all.
Yes, I will submit the written notes.
हम आपका पूरा डिटेल में दे दिए. आप कोई रिटन नोट्स ऑफ आर्गुमेंट का जरूरत नहीं है. आप सब चीज नोट कर चुके. I don't need any written notes of argument.
And there is another judgment, 1994, Andhra Pradesh. Which says that the
पेज नंबर भी है कि नहीं है 94 आंध्र प्रदेश का? पेज नंबर AIR है.
AIR
पेज नंबर बताइए. क्या लिखे 260 पेज नंबर लिखे हैं, जजमेंट दिखाइए। सर प्लीज ऐसा मत करिए, हम ना इस तरह से ना आप जजमेंट मत साइड करिए जो आप कोर्ट पे नहीं दिखा सकते। आई विल नॉट रिकॉर्ड दिस जजमेंट, व्हाई शुड आई? ओके चलिए। नहीं सप्लाई नहीं, आप आर्गुमेंट के समय नहीं प्लेस किए तो आप ऐसे सप्लाई करने से कुछ नहीं होता। यू शुड हैव ब्रॉट द जजमेंट। Yes, please.
First of all, Lordship, I'm just giving my details. First of all, Lordship, I give some important dates. And thereafter, Lordship, one by one, unsubstantial.
Yes.
That
I expect this from you.
Yes, it's only that.
We have to confine to
Yes,
substantial
it's
question
only
of
that,
law
that.
as a rule.
Since my routine is also on that grounds.
Yes.
Only on those grounds. Lordship, the suit was filed on. Dates are important. 6-7 dates Lordship I have given.
Yes, yes.
Suit was filed on 11/12/1980.
Yes.
The date of exhibit 5 Lordship, which is my agreement, that is dated 18/9/1980.
18/9/18.
That is exhibit 5.
Yes.
Thereafter, Lordship, the agreement in favor of defendant number 2, as per them, I will be showing that how this is false and fabricated agreement, is 20th August 1982. Sale deed was executed on in favor of defendant number 2 by defendant number 3.
इसका एग्जिबिट नंबर बता दीजिए।
Lordship,
एग्जिबिट नंबर
that is 20/12/82.
इसका एग्जिबिट नंबर
Exhibit.
आई थिंक बी है।
That is B.
बी इज अ स्टेटमेंट मे बी।
क्या है?
बी इज द एग्रीमेंट। एग्जिबिट बी।
Lordship. Thereafter, Lordship, please.
डिफेंडेंट नंबर 2 का सेल डीड का डेट है
Now, Lordship, defendant number 2 and 3 were added as party.
1982. Just a moment. Defendant number 2 and 3.
Were added as party on 25/3/1980.
One more question. Your agreement is with power of attorney or with
No, with the original.
original
By
defendant?
defendant number 1.
Defendant number 1. So power of attorney was not there in picture for your agreement.
For my agreement, and this is the property of exclusive property of
Yes,
defendant
yes.
number 1. That should be clear. Now, 2 more dates are important that I am giving. Defendant number 3 had filed a partition suit against defendant number 1, his own grandfather. That is exhibit 5. This was filed on
This is exhibit
exhibit 5.
5.
This was filed on.
No, you have said agreement is exhibit 5. Agreement is exhibit 2 perhaps.
No, agreement is exhibit 2, but blank is exhibit 5. Just that.
Yes. Okay.
This was filed on 25/11/1980. The dates are very important. The suit was subsequently withdrawn by exhibit 6.
What was the suit number?
Suit number is partition suit 278 of 1982.
278 of 1982. What is the date of withdrawal?
Date of withdrawal, Lordship, is 2/8/1983. And this finds place, Lordship, in page 9 of trial court judgment also. Now these are the questions. They have, Lordship, the first substantial question of law which was modified. It is whether the concurrent finding is important. With the concurrent finding recorded by both the courts that the plaintiff was ready and willing to perform his part of the contract suffers from any purpose. Now on this, Lordship, I just submitting. Also, कल एक और चीज आया था, बड़ा important. This is the certified copy, Lordship, of the exhibit of the depositions. और डिफरेंट नंबर PW1 के बारे में कहता है, ऊपर यहाँ पे स्टैम्प मारा हुआ था, हटाया गया।
हाँ।
ये हम 87 में एक साल के बाद निकाले थे, उस समय का सर्टिफाइड कॉपी यहाँ कहीं नहीं।
क्रॉस एग्जामिनेशन भी हुआ?
कुछ नहीं, क्रॉस एग्जामिनेशन हुआ है और हम ऑर्डर शीट भी चेक किए हैं विदाउट एनी एप्लीकेशन दैट इट शुड बी एक्सपंज्ड एंड विदाउट एनी ऑर्डर ऑफ द कोर्ट। वो स्टैम्प आया कहाँ से?
सर्टिफाइड कॉपी निकालते समय वो लोग लगा दिया होगा कि हटाया गया है, उसके बाद फिर लगाया होगा। We do not.
That is the thing.
ये कोई ऑर्डर से हटाया गया है सर? एक्सपंज हुआ है PW1 का एविडेंस बाय एनी ऑर्डर? ऑर्डर तो होना चाहिए ना, क्योंकि क्रॉस एग्जामिनेशन है उनका एंड क्रॉस एग्जामिनेशन क्लोज्ड है।
उसका कोर्ट ने रिलाई नहीं किया है।
रिलाई नहीं किया अलग बात है, लेकिन आपने सबमिशन किया है कि इसके एविडेंस को हटा दिया गया।
हाँ, लिखा हुआ है।
कहाँ लिखा हुआ है सर? कौन से ऑर्डर शीट से हटाया?
ये बस
ये लिखा हुआ है कि हटाया गया।
सर आप हमको पूछ रहे हैं कोई ऐसा ऑर्डर शीट है जिससे हटाया गया?
सर्टिफाइड कॉपी निकाले, सर्टिफाइड कॉपी में यही प्रोवाइड।
कोई बात नहीं सर, कोई ऑर्डर शीट है कि उसको हटाया गया है? कोई ऑर्डर शीट में होगा ना, दिस एविडेंस इज एक्सपंज्ड।
ओरिजिनल तो
आप देख लीजिए, आप अपना देख लीजिए।
आप क्या तो ओरिजिनल तो वही लगा हुआ, हटाया गया लिखा हुआ।
हम आपसे ये पूछ रहे हैं कोई ऑर्डर शीट से उसके एविडेंस को एक्सपंज किया गया है?
हम ये बता रहे हैं कि कैसे कोर्ट प्रोसीड किया।
ठीक, लेकिन कोई ऑर्डर शीट नहीं है ना।
2 तारीख को नहीं, उसने क्या किया देखिए क्यों हटाया गया। वो एक कागज लाया था, एक एग्जिबिट बड़ा इंटरेस्टिंग है, अगर उस पर बोल ही देंगे हम दिखाई देते हैं। वो एग्जिबिट क्या था, आधा पेज का एक लीगल नोटिस था और उसको एग्जिबिट कराया गया जिसमें किसी का साइन नहीं था और इसलिए उसको हटाया गया। ये मेरे अगेंस्ट में ये किया गया। उसका एग्जिबिट देखा जाए, एग्जिबिट 1 को तरह से देखा जाए, आज तक नहीं देखा गया है, जरा से देखा। वो आधा पेज का लीगल नोटिस को ला करके
बात है सर, प्लीज अप्रिशिएट। अगर मान लीजिए कोई डॉक्यूमेंट है, ट्रंकेटेड है, तो कोर्ट उसको डिसबिलीव कर देगा, लेकिन पूरा एविडेंस उठा के फेंक देगा, ऐसा तो नहीं है ना।
Madam, I said part of it. I'm an appellant. I don't say that the things were very cogently dealt with. The things were not dealt with in.
I'm just recording it that there is no order expunging his.
Just kindly have a look at exhibit number 1.
I've seen it.
Half-page document. It's a half-page document, and it was sought to be proved by him, and that is why they managed to get it deleted. अगर ये डॉक्यूमेंट को लाया जाता रिकॉर्ड पर, पूरी गवाही उसको दे देते हैं, क्या बोला?
अब सर अब आप बैठ जाइए प्लीज, इनका सबमिशन हमको नोट करने दीजिए। आपको डिस्टर्ब नहीं किए थे ना। एक सवाल आपसे पूछे,
आपने जो पूछा था
बस एक ही सवाल। नहीं, एक ही सवाल आपसे पूछे,
उसी का आप जवाब दे रहे हैं।
सर हम आपसे सिर्फ, मेरा सवाल बहुत
ये ऐसा प्रिटेंड किया जा रहा है कि एवरी फाइल और डन समथिंग। इनके सर्टिफाइड कॉपी में अगर नहीं है तो
ऐसा हम नहीं रजिस्टर कर रहे।
कैसे है?
ऐसा हम नहीं रजिस्टर कर रहे। हम पूछ रहे हैं कि एक विटनेस का गवाही हुआ, उसका क्रॉस एग्जामिनेशन होके क्लोज हुआ, तो क्या कोई ऐसा ऑर्डर शीट ड्रॉ हुआ कि दिस विटनेस का एविडेंस इज टू बी
ऑर्डर शीट तो इस बात पर भी नहीं ड्रॉ हुआ कि हमने ऑब्जेक्शन किया, तो गवाही में लिखा हुआ है आपत्ति के साथ। ऑर्डर शीट उसको भी 3 वर्ष तक ऑर्डर शीट।
अच्छा प्लीज बैठ जाइए सर, बैठ जाइए प्लीज।
ऑर्डर शीट तो जैसे मेंटेन
सर प्लीज हैव अ सीट।
हमने तो पॉइंट आउट किया था उस दिन में कि ऑर्डर शीट यहाँ ढंग से नहीं मेंटेन।
सर प्लीज बैठिए, प्लीज हैव अ सीट।
now we can reply or only.
How about it?
No lordship from the print, I will just referring paragraphs. In print lordship para 7, 9 and 11, specific reading of, because I am not again reading it. If lordship believes, then we are listening.
7, 9 and 11.
It is very much evident that we have treated our readiness and readiness. In very short and crisp manner, lordship understand this. Exhibit 3 is lordship the notice is reply to the notice to defend number 1 and 1 and 3. That also we have stated. PW4 is the plaintiff lordship. In his para,
Exhibit 3 is a legal notice.
lordship. Reply to the notice.
Who's
There
replying?
also we have stated.
Who's replying?
Lordship.
Who's replying?
The plaintiff.
They sent you a legal notice.
Yes.
They sent you a legal
Yes.
notice. What is that legal notice?
That legal notice says lordship that we have purchased this property and look here, you don't interfere in all these things. If lordship wants that, I read it.
No, it's okay. I just want to know.
Yes.
What is the date of this?
बीस 11 and our reply lordship is that is exhibit 3 lordship, that is 30-11. This is our reply, which was received by the defendant number 1. Although they are saying that this was sent on the same day.
Yes, absolutely.
Yes. And but the signature lordship has never been disputed. He is the person who has received. Now, plaintiff lordship PW4 as also stated in paragraph 3, 4, 5 and 6.
Yes.
Now, lordship, the defendants have never pleaded that the plaintiff was financially incapable. The endorsement on the exhibit 2, that is my agreement, and the back side of it. Again, defendant number 1 acknowledges of receiving rupees 1,000.
Exhibit 2.
2 at the endorsement at the back side.
Receipt of
Rupees
1,000.
1,000. Later on, lordship. Thereafter, the agreement was extended.
What is the date of this receipt?
Lordship.
And what was the total consideration amount?
Total was 10,000. 2,000 was paid at the time of entering into the agreement.
1,000 on date of exhibit. And then
And lordship, thereafter, 1,000 was paid later on on 11/10/1982, which is marked as exhibit 2/1 endorsement.
yes.
Thereafter, lordship, what they have pointed out, exhibit 2/2, whereby this agreement was extended till 30th November 1980. Although it relates to another substantial question of law, but still I am pointing out.
30/11/19.
1982. This is the extension of it. Now, the role of this exhibit when it comes, It is only for the purpose of limitation.
For the purpose of-
For the purpose of limitation, that the suit for its specific performance is to be filed within 3 years. But here is the case, that even if the extension was not there, if it is not properly stamped, what my learned friend is saying, it will have no bearing in the case at all. It is for another substantial question of law, Lordship, but still I am pointing it out here. That is the third substantial question of law, which was later on formulated.
No, it is exhibit 2 by 1, not exhibit 2 by 2. The third substantial question of law is on exhibit 2 by 1 and not 2 by 2.
But Lordship, the wording of the substantial question of law.
We will not go by the wording.
Yes, yes.
Exhibit is specifically mentioned.
Yes, yes. But Lordship, by 2 by 1.
2 by 1 is payment of rupees 1000.
1,000. एक
Stamp act.
उसमें दोनों चीज, पहला चीज है at the time of agreement and rupees 1,000 at the time of extension on 11/10/1982. What I am submitting that the 1,000 is received by Yugal Kushal Prashad, which shows that he was also capable. But exhibit 2 by 1 or exhibit 2 by 2, both are.
You see, it is marked as exhibit 2 by 1 was inadmissible in evidence for the same being not duly stamped.
Yes.
So this is confined to exhibit 2 by 1. We will not take it to exhibit 2 by
2
2.
by 2 मत लीजिए, 2 by 2 उसी का एक्सटेंशन है. हम 2 by 1 नहीं, यही बस हम 2 by 1 नहीं कर देते हैं. हमारा ये कहना है कि this extension of time can be by way of, because it was not properly stamped. But they cannot say that 1,000 was not received by him when his signature is there and it is not disputed.
So if the document is inadmissible in evidence, then under such circumstances, anything contained therein,
Even
it will not be taken into evidence.
I am also accepting what Lordship is saying. Even if it is at all accepted for the sake of argument that 1,000 was not paid at that time, what was my remedy? My remedy was to file a specific performance suit. That too within time. It is filed within time. Agreement is not disputed. Agreement is there. Just within 3 to 4 months, I have filed a suit for a specific performance. Because this old man, defendant number 1, was under so much pressure of his grandson that he was doing all these things. Although he was very much capable at that time.
You see, by exhibit 2 by 2, the period was extended till
30th November 1982. ये यहाँ भी लिखा है.
And the suit was filed on 11/12/1982.
12-15 दिन बाद हमने फाइल कर दी. Even that is not taken into consideration. Original agreement is taken into consideration. It was for a period of 1 month. The agreement has to be valued within 1 month. It was not valued, and therefore I have a 3 years time, right from when the cause of action arises. If at all we take that as a cause of action, then also our suit is maintainable, and it is only for the purpose of whether I am coming within the limitation or not. Even if 1,000 is also not taken into consideration by some court, then also I have a right to file a suit because the cause of action arises. That should be the law is that should be that within the limited.
This stamping of exhibit 2 by 1 is covered by which provision of the Stamp Act?
That's several judgments have been given on that.
Which
Section
is that?
36 of the Indian Stamp Act. And a very celebrated judgment on that question is AIR 1978 Supreme Court 1193.
1978
Supreme Court
Supreme Court.
1193.
नहीं मंगाई सर. आप लाएं?
Okay, let's
ये क्या
We
है
have-
ना ऐसे.
try to get everything, but I'm trying to but it's not.
ये क्या है जी ऐसे खाली जजमेंट ड्रॉप कर देते हैं.
this section says that power of impounding is there. The court has to impound, and whatever required is to be paid by the person concerned who is relying upon them.
And this also says that the state government may make rules providing that where an instrument bear a stamp of sufficient amount but of improper description.
What
This
is
is
the
36.
I'm just may I explain it. Since we have done a case in that also. इसमें होता क्या है कि when the court impounds, it calls for the report from the citizen. What amount is required to be paid by the plaintiff or the person who is relying upon a document which is insufficiently stamped or not stamped. After impounding lordship, when the report comes, thereafter the order is given to the plaintiff or the defendant, whosoever it may be, who has relied upon that document, to deposit that amount of court fees, so that it may be taken into consideration by the court, and the exchequer is also does not suffer.
The moment that objection is taken.
Yes, but the objection for the first time is being taken in this honorable hearing.
Is there any monetary limit for this, that or even 1 rupee has to be stamped? No, I want to know.
100 के ऊपर का है, पर आप एक बार उसको चेक करो, the right question.
Because हो सकता है 1 रुपए का पेमेंट
हाँ,
हो,
उसका क्या है?
उसका मतलब
जैसे कि
what is the
में, जैसे रजिस्ट्रेशन एक्ट में कि 100 से अंदर का रजिस्ट्री का रिक्वायरमेंट.
I just want to know, is there any rule or anything of that sort? Anyways, tell me. Okay. This is on stamping. This is on stamping.
हाँ, इसको कोई स्टैम्प. पूछा गया है, कह रहा है कि बोला गया है कि whatever I'm not. The DW2 lordship is the Barish Prashad. He is the witness to the execution of the agreement. He has also proved that the person who was making an agreement was fully capable at that time. I'm not reading parawise lordship. If lordship wants that, I can do that.
But he is not a witness to the agreement.
He is not a witness to the agreement.
He has simply said that he had seen it.
Yes.
But he is not a witness.
In
to the
para
agreement.
5 lordship he says that. And thereafter PW3, Kashi Prasad Sahu lordship is an advocate. And the agreement was written by him. He also states the same thing in my favor. No contradiction was shown by
It is
me
in his writing.
in his writing. In para 5 lordship he says.
Parapile again. PW3 also parapile.
Now, on these basis, lordship,
You see, agreement is not in dispute. So let us not enter into the
Yes,
arena.
yes.
What is in dispute is readiness and willingness.
readiness.
He has also raised a point that there was no issue framed on readiness.
Yes.
That also he has raised.
Yes. On that
Just a
point,
passing,
yes.
just a passing point was taken that no such issue was
But
framed.
now, lordship, how contradictory now the substantial question of law is. Therefore, since they have got it framed, what is the substantial question of law? Whether the concurrent finding, I was also wondering that how this substantial question of law was there. Whether the concurrent finding recorded by both the courts,
Yes.
when it was modified version,
Yes.
whether the concurrent finding recorded by both the courts that the plaintiff was ready and willing to perform his part of contract suffers from any purpose. This is what the substantial question of law, and I am supposed to answer on this. And now it will be taken as that there was a concurrent finding, although the issues were not framed. It has been touched by both the courts, and therefore this substantial question of law has been framed by the appellants.
And at their instance, it has been modified.
And now it has been modified by them. Now, lordship, on this lordship, only one judgment I am giving, that is para 20 and 21. The Honorable Supreme Court says that if the finding of the concurrent finding is there, 2019 volume 3, SCC 520 para 20 and 20.
20 and
20 and 20, very small.
21.
B6. ऊपर में लिख Although the issue was not framed, but still it is not in my favor. A finding on the issue of readiness and willingness is one of the important and relevant findings in the suit for specific performance of an agreement. It is a finding based on facts, and once it is recorded, it becomes a finding of fact. Thereafter, in this view of the matter, unless such finding is found to be against the pleading or contrary to the evidence or the law governing the issue, it is binding on the High Court and also on this. This is on the Supreme Court is saying. Now it is a finding of fact, and they have got it framed themselves. Therefore, now they cannot take a plea that the issue was not there. Now the issue was already decided. A specific issue was not framed. It was decided touching this issue whether he was ready and willing to perform his part of contract or not. And both courts have held in my favor that he was ready and willing to perform his contract. And the pleading is also not there otherwise. No pleading in the WS by both of them that I was not ready and willing to perform the part of the contract. They have brought out a different story altogether. What story and
They
how
must
they
have denied your submission, your statement. It must have been denied.
Yes,
General denied maybe.
उनका हम जरूर WS पढ़ेंगे उसको. क्या deny की है? Lordship will see that we can't. Defendant number 1 नहीं. 1 तो इशारा old man से क्या फर्क है? He was so afraid of his grandson.
So readiness and willingness to perform the part of the contract.
Yes.
Since the contract was entered directly with the defendant number 1,
Yes.
so it was he who had to
He
deny
had.
it.
Yes.
Because there is no entry of power of attorney holder at
Yes,
that
not
point.
at all. Not at all. Even then, not sure. How
You
contradictory
see,
stand there?
whenever any power of attorney is executed, then under such circumstances, it does not delude the owner to enter into any deal.
Yes.
He does not say that
No.
I will not deal with it.
He does not limit
That
his
is
power.
not a transfer.
No.
He does not limit his
He
power.
does not limit his power that I cannot do anything
There
now.
could be a situation that the owner is also entering into some deal. The
Yes.
power of an attorney is also entering into some deal.
Yes.
Can happen.
Therefore, my submission is on this point. I was coming to that point. Question is rightly pointed out. Since defendant number 1, who was the main person and capable of denying my readiness and willingness,
Yes.
not sure. Therefore, my submission is, since defendant number 1 has not come to the court, it cannot be said that if it does not come, the court shall shut its eyes and pass a judgment in my favor. But even then, adverse inference is to be drawn that when it is such a heated thing, the son-in-law has got the property, the grandson is fighting with me. Defendant number 2 is the son-in-law.
Son-in-law?
Yes, अपना दामाद है. But the defendant number 1 is not coming, this old man, because at that time if something has been done by some respectable person of the society, it does not have the courage to come to the court and say otherwise. That is my
Has he been
understanding.
examined as a witness?
Oh, no.
Defendant number 1?
No. Neither as a witness.
Did he die prior to the?
No. उसका तो आया हुआ है, judgment में आया हुआ है. दोनों कोर्ट के जजमेंट में आया हुआ है कि neither he deposed nor he has given his WS. Therefore, adverse inference has to be drawn. हम ले
Okay.
Now, Lordship, the WS of defendant number 2, who is the son-in-law and subsequent pursuit. यह कि चरण 3 को आंशिक रूप से स्वीकार करता हूं।
Just a moment. WS of defendant number
subsequent purchaser, son-in-law of defendant number 1. और defendant number 3 के फूफा
defendant number 3.
फूफा और defendant these two WS lordship will clarify everything. यह कि चरण संख्या 3 को आंशिक रूप से स्वीकार करता हूं। वादी मात्र एक किराएदार है, मासिक किराया अदा करने में का कथन पूर्णतः असंख्य है। चरण 4 से 11 या अस्वीकार किया है। चरण 4 से 11 अस्वीकार है। डायरेक्टली एक लाइन में लिखते हैं, चूंकि यह प्रतिवादी संख्या 2 ने 2 से सीधा संबंध नहीं रखता। चरण 11, 12, 13, 14, 15 और 16 विधिक होकर उसकी उत्तर की आवश्यकता नहीं है। इसकी भी आवश्यकता मतलब राइट फ्रॉम पैरा 4 टू पैरा 16 कोई जवाब इनको देने की आवश्यकता नहीं है, इनसे ताल्लुकात नहीं रखता। यह कि चरण 17 के प्रथम अंश को अस्वीकार करते हुए शेष को स्वीकार करता है कि उपरोक्त मकान को रजिस्ट्री पट्टा के द्वारा खरीद किया गया है, इनके द्वारा खरीद। यह कि चरण 18 को आंशिक रूप से स्वीकार करता है, यह भूमि सदा मकान का नगद 15,000 रुपया देकर मकान खरीद किया गया है। यह कि प्रतिवादी संख्या 3 ने प्रतिवादी संख्या 3 श्री राम किंकर पाठक प्रतिवादी संख्या 1 का होता है, जिन्होंने प्रतिवादी संख्या 1 से सन 1977 में अपना मुख्तारनामा आम लेकर दिया, जिसका रजिस्ट्री रांची सब रजिस्ट्रार के कोर्ट दिनांक 13/7/1976 ईस्वी है। इसका प्रमाण संख्या इतना है, पट्टा नंबर इतना है और यह अत्यधिक प्रभावकारी है, जिसका फोटोकॉपी इस प्रतिवादी के अनुलंघन 1 में संबंध है। यह प्रतिवादी संख्या 2 श्री राम किंकर पाठक को दिया गया मुख्तारनामा आम को अच्छी तरह से सोच समझकर पढ़कर दिनांक 20 अगस्त 1982, अब दिस वेरी इंपॉर्टेंट, इट इज इन पैराग्राफ 8, 20 अगस्त 1982 को उनके साथ उपरोक्त वर्णित भूमि सुधा मकान की खरीदगी का एक इकरारनामा आपस में। This is lordship in paragraph 8, defendant number 2 is saying that there was a prior agreement dated such and such, but in the WS of DW3 no such statement is there. You have already executed a agreement in favor of defendant number 2.
20/8/82 क्या है?
20/8/82 हुजूर
ये तो एग्रीमेंट है।
हाँ, ये जो एग्रीमेंट इनके फेवर में किया गया डिफेंड नंबर 3 के द्वारा,
हाँ।
बीइंग अ पावर ऑफ अटॉर्नी होल्डर,
हाँ।
ये अपने डब्ल्यूएस में कहते हैं 1983 में लोग ऐड हुए, उसके बाद का डब्ल्यूएस है, उसमें ये कहते हैं कि हमको एक एग्रीमेंट हुआ था, बट DW3 ऐसा कुछ नहीं कहते कि हमने उनको एग्रीमेंट किया था। This is very important, and moreover what he says,
he is referring to the this para 8 is referring to the agreement
agreement is
dated
one agreement.
38/1980.
हाँ,
So what discrepancy do you want to point out? in
I
this?
just want to say that this is, if had this been an agreement, because I am saying that it was a fictitious agreement, later on brought on the record, had this really been an agreement, तब जो डिफेंडेंट नंबर 3 जो अपना डब्ल्यूएस दे रहे हैं, उसमें इसका जिक्र करते हैं ना
हाँ।
कि हमने उनको एग्रीमेंट कर दिया, जैसे ये कह रहे हैं कि हमने उनसे एग्रीमेंट कराया। दिस इज नॉट देयर, रादर व्हाट ही इज सेइंग, हम अभी पढ़ेंगे उसको आगे, कि हमारे पास पैसे की कोई कमी नहीं थी, जमीन बेचने का हमारे ग्रैंडफादर को कोई जरूरत नहीं था, इसलिए जमीन नहीं बिकना चाहिए। अब यहाँ भी एग्रीमेंट कर चुके हैं, अभी आगे और आएगा, सारा खुल जाएगा एक एक करके। हाँ आपको पैराग्राफ से बता दे रहे हैं कंडक्ट आपका भी तो कंडक्ट दिखाया जाएगा आगे हमारे थोड़ी यह कि प्रतिवादी संख्या 3 संबंधित कानून सदा भूमि जिला जिसका विवरण नीचे दिया गया है एकरारनामा के अनुसार शेष राशि का नकद भुगतान करके 20/12/82 को खरीद लिया गया। फिर आफ्टर इतना ही का है और लास्ट पैराग्राफ 11 है। यह कि प्रतिवादी संख्या 3 उपरोक्त मकान का वैध अधिकार से विधिक रीति से खरीद लिया गया है, इसलिए इस बात को उसे भागीदार बनाना न्याय संगत प्रतीत नहीं होता। खुद ही कह रहे हैं कि हमको पता नहीं क्यों बना दिया गया।
But he's not saying that he is in possession of it.
No, पोजीशन तो ऑलरेडी शुरू से हमारी
नहीं, ये बोल रहे हैं पोजीशन मिल गया, म्यूटेशन हो गया।
नहीं पोजीशन उनका रेंट रिसिप्ट हो गया, होल्डिंग नंबर उनके नाम से आ गया, वो सब चीज है, बट पोजीशन तो कभी नहीं है, दोनों कोर्ट ने भी नहीं माना, उस पर कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं। अब क्या करते हो 40 साल में उसको कवर कर दिया। Now the WS of defendant number 3.
Defendant number 3.
Defendant number 3. Easy करेंगे। इसका पैराग्राफ शुरू को हम नोट कराए थे और लंबा है और ये बड़ा इजीली हो जाएगा और हम हल्का हल्का सबको पॉइंट को टेस्ट करेंगे विदाउट रीडिंग एज अ होल।
हाँ, पैरा
1 2 3 5 9 11 14 and 15. Defendant number 3 is Ram Kinkar Pathak, grandson of defendant number 1. अब ये कंडक्ट के बारे में कहते हैं पैराग्राफ 1 में, हम बड़ा शॉर्ट में चूंकि हम बनाए हुए हैं बड़ा इजीली हो जाएगा।
ठीक।
1986 से किराया देना बंद कर दिया गया, ये हमारे इनके डब्ल्यूएस में है। मैंने अच्छा ये डिपोजिशन हम डिपोजिशन वो डिपोजिशन है उसको डब्ल्यू पैराग्राफ में नोट किया ये डिपोजिशन है।
डिपोजिशन ऑफ
DW3 डिफरेंट नंबर 3 राम टीकर पाठक
ये DW
ये खाली लिखा है डिपोजिशन ऑफ DW3 राम टीकर पाठक, ये इनका उनका DW1 होगा। 1 लिखता है डिपोजिशन ऑफ डिफरेंट नंबर 3 राम टीकर पाठक, ये वो
DW1 है।
हाँ
इसका पैरा 1
हाँ ये जो पैरा नोट किया है डिपोजिशन और ये क्या है उसको हम बाद में पढ़ेंगे इसको पहले
14 and 15 ठीक।
इसको हम बाद में एक्सप्लेन करेंगे, पहले हम डब्ल्यूएस में गए। ये प्लेंट का रिप्लाई वसूल किए हैं पैराग्राफ 6 paragraph 8 Lordship I am reading that if there be any agreement in the year 1982 the said to be made by defendant number 1 in favor of plaintiff, it is illegal, void, without consideration, inoperative and sham transaction. The defendant number 1 had no legal right, title or power to enter into such agreement without revoking the registered power of attorney if it succeeds. The price of rupees 10,000 is also too small. This is what we is saying. Thereafter in paragraph 9 Lordship, the plaintiff has prevailed over defendant number 1. Here it is very important Lordship. The plaintiff has prevailed over defendant number 1, taking advantage of his state of mind and health, and if there be any signature in any agreement, it has been obtained by the plaintiff by practicing fraud, coercion and undue influence, or by suppressing material facts of the documents. The defendant number 1 had no legal power to enter into agreement. The plaintiff has had the full knowledge of the registered power of attorney in the year 1977 executed by defendant number 1 in favor of defendant number 3. Thereafter paragraph 11. The contents of made in para 7 of the plaintiff has replied elsewhere in WS. The plaintiff, by introducing the name of the Shri Kashi Prasad Sahu advocate in the manner stated, seems to collect evidence from before apprehending to guard his knowledge and ignorance regarding existence of general power of attorney of 1977. Since Lordship, this advocate had said something and therefore it was stated in this note. Paragraph 9. The question of execution of the sale deed alleged by the plaintiff does not arise. The said power of attorney of the year 1977 shall prevail over any other document, and that the general power of attorney still holds good in the eye of law. The general power of attorney has not yet been revoked according to law. The alleged agreement of the plaintiff by any illegal intended fraud is held by the principles of Indian Contract Act and such and such.
Basically, since there is a power of attorney, the original owner cannot do anything.
Yes, yes. अभी हम 2-3 पैराग्राफ में आएंगे. In para 11, there is a question of payment of. There is no question of payment of compensation. He is not entitled to any relief or assistance. A man of ordinary prudence, more so by advice of the advocates K.P. Sahu, would have inquired in the local registry office about this deed. The plaintiff has played the trick to gamble with the money in the gained to seek the knowledge fully well about this general power of attorney of 1977, about the serial defendant number 2, defendant number 2, about the Ranchi Municipal Corporation in the name of the defendant number 2, and all other facts. They were not tried to such. That the plaintiff has no cause of action filing suit. The plaintiff has property and with the ulterior motive has purchased trouble, knowing fully well that defendant number 1 had no power and interest and no status to enter into any agreement in the presence of the registered general power of attorney. Only on the power of attorney, thereafter Lordship, lastly, in paragraph 90, the Ram Kinkar Pathak had no knowledge for filing of this suit at the time of the said, at the time he sold the said property. It is important, Lordship, it is entirely contradictory to what he has stated deposed and the partition suit also. The Ram Kinkar Pathak had no knowledge of filing of the suit at the time of the sold property of defendant number 2. The plaintiff had full knowledge of the fact that defendant number 1 had no right to enter into any agreement for sale in view of the registered general power of attorney. As stated earlier, the plaintiff had full knowledge about the registered general power of attorney and about the sale by defendant number 1 to defendant number 2. That the sale of defendant number 3 to defendant number 2 is real and legal sale for consideration, and it is not a sham transaction. The plaintiff is not entitled to any relief. Now, Lordship, paragraph 20 is important. In paragraph 20, he is acknowledging about registration of the sale deed, but there is no mention of prior agreement in the month of August. Para 19 and 20. Para 20 is specific.
No mention of any prior agreement.
Prior agreement in the month of August, in the entire plan, in entire address. And why he has not mentioned that, I'll be referring from his deposition. Now, what's the deposition which I have just pointed out? This deposition is to be seen basis.
The sale deed mentions the prior agreement.
Not
The sale deed mentions the prior agreement.
sale deed mentions. Very, very clearly they have done this, but forgot to write in his WS. Is Karnataka in there? The paragraph which I just noted, Lordship, after deposition.
Ram Kinkar Pathak.
पैराग्राफ 1 में कहते हैं 86 से पूर्व किराया देना बंद कर दिया गया. पैराग्राफ 2 में कहते हैं मैंने
Just a moment. He has been examined as DW1, no?
DW1 को कुछ है इसमें लिखा हुआ है. राम किंकर पाठक for defendant number 3 DW1. लिखा है.
Yes.
शॉर्ट टर्म बना है उसको नहीं कह रहे
हाँ।
हैं। 86 से पूर्व किराया देना बंद कर दिया, ये पैराग्राफ 1 में। पैराग्राफ 2 में है, मैंने DW2 से इकरारनामा किया, दिस इज इन हिज डिपोजिशन बट नॉट इन WS. It is beyond the pleading. Whatever he is arguing, is submitting before the court, deposing before the court, is beyond the pleading. Cannot be taken into consideration. Now, paragraph 3. युगल किशोर पाठक की उम्र 100 वर्ष की होगी, और उसी पैराग्राफ में लिखते हैं, and this was deposed on 4/8/1987. The date is important. This was deposed on 4/8/1987, और उसी में लिखते हैं कि retired in 1962. 62 में युगल किशोर प्रसाद, युगल किशोर पाठक की उम्र करीब 100 वर्ष की होगी, वे कचहरी नहीं आ रहे हैं, चूंकि चल फिर नहीं सकते। इसको पढ़ ही लेते हैं, क्योंकि इनके फादर जब आके डिपोजिशन करते हैं वो कुछ और कहते हैं, इन्हीं के फादर चल फिर नहीं सकते हैं, उनकी आंख और नजर ठीक से नहीं, उनकी नजर भी ठीक नहीं है। उन्होंने एक शिक्षक से 1956, फिर कहते हैं 1962 में सेवानिवृत्त हुए। इसका मतलब हुजूर 87 में जब वो डिवोर्स कर रहे हैं, he was 85 years of age. वो हमारा कहना था 80-85 के उनके। उसके बाद जो पैराग्राफ 5 में आ गया, मुदई शर्मा जी कभी हमको किराया नहीं देता था, हमने उसे पावर ऑफ अटॉर्नी नहीं दिखाया। He mentions that, admits. Thereafter, what she paragraph 9, he admits to file a partition suit. मैंने बंटवारावाद को वापस लिया, चूंकि युगल किशोर पाठक ने कहा था कि आपस में सुलझ जाए। बंटवारावाद वापस लेने के बाद पाठक जी शर्मा को कहने गए कि घर छोड़ दीजिए। शर्मा ने कहा कि हम घर खाली कर देंगे, आज एक किरायानामा ले लीजिए। ये इनका पैराग्राफ 11 बहुत इंपॉर्टेंट है। जस्ट उसके बाद है वादी की ओर से, दिनेश्वर पाठक हमारे अपने फूफा, तकरारी संपत्ति के बगल में भी उनकी संपत्ति है, हम लोग उनके साथ परिवार की तरह हैं, इसलिए बराबर आना जाना लगा हुआ है। दिनेश्वर पाठक को हमने सिर्फ तकरारी भाग को बेचा है। अगस्त 1982 में दिनेश्वर पाठक को बेचने की बातचीत और हमने दिसंबर 1982 में बेचा। इस बात को हमने युगल किशोर पाठक को बताया था। 20/8/82 को हमने इकरारनामा लिख दिया। वही वादी नारायण प्रसाद शर्मा में इनके संबंध का जिक्र नहीं किए थे। पैसे की जरूरत थी, इसलिए दिनेश्वर पाठक को बेचने की जरूरत पड़ी। इकरारनामा के समय पिता की ओर चाचा की भी मैंने पट्टा दाखिल कर सकता हूं, फिर कहते हैं कि मूल हो गया है। ओरिजिनल पट्टा के बारे में बात कर रहे हैं। प्रमाणित प्रति दाखिल कर सकता हूं। 1982-83 में मेरे दादा जुगल किशोर रांची आना जाना करते थे। अब यहाँ पे कहते हैं 82-83 में मेरे दादा जुगल रांची आया जाया करते थे। इस नोटिस को पैराग्राफ 12 का रूल पीछे पढ़ रहे हैं। इस नोटिस को देने के पूर्व मुझे मालूम नहीं था कि मेरे दादा के साथ इनका इकरारनामा हुआ है। Now paragraph 14. फिर आगे भी दूसरे पैराग्राफ में है कि अगस्त 82 के पहले रांची नहीं आए थे, वे सितंबर 82 में रांची आए थे। अबाउट हिज ग्रैंडफादर नारायण शर्मा के संबंध में उनसे बातचीत नहीं की। जुगल किशोर पाठक के दस्तखत को देखकर कहते हैं कि उन्हीं का दस्तखत। मेरे दादा पाठक नवंबर 82 में भी रांची में थे। He comes and goes to Ranchi from Gaya and Chakra. Now paragraph 14. इस बात में विपक्षी इस बात के मेरे दादा के इस बात के विषय में मेरे दादा से बातचीत हुई है। मैं नहीं कह सकता हूं कि मेरे दादाजी की ओर से इस बात में जवाब पड़ा है या नहीं। मैंने उनसे नहीं कहा कि आप प्रतिवादी संख्या 1 हैं। Never told to his grandfather. आपको जवाब देना पड़ेगा। वे अस्वस्थ हैं इसलिए जवाब नहीं दिया। मैंने जवाब देने से पहले अपने दादा से कोई राह सलाह नहीं। Therefore, he is not imposing as power of attorney. Although Lordship the Vakalkana was filed in the trial court as the power of attorney holder, but since it has come in the trial court judgment, but since the deposition was there, the court did not take into consideration.
He is not deposing in the capacity of power of attorney.
No, it's not deposing. और he says कि हम बातचीत ही नहीं किए तो power of attorney holder कैसे हो सकता है? उनकी तरफ से कैसे डिपोज कर सकते? मैंने दादा को बताया कि हमने पार्टीशन सूट किया है। हमने अपने दादा को नहीं बताया कि चूंकि आपसे नारायण शर्मा का इकरारनामा किया इसलिए पार्टीशन सूट किया है। पार्टीशन सूट की अर्जी मोहन पाठक ने बनाया था। Now paragraph 15. रांची 20/8/82 का इकरारनामा रांची में हुआ था। मार्च 82 में जमीन बिक्री की बात चल रही थी। मार्च 82 के बाद मेरे दादा रांची आए थे कि नहीं मुझे याद नहीं। मेरे दादा तामिला के पहले इस संबंध में बातचीत प्रदर्श बी के तामिला से पहले इस संबंध में बातचीत हुई थी। मेरी ओर से बयान तहरीर दैट इज WS मोहन लाल पाठक अधिवक्ता ने किया है। मोहन लाल पाठक मेरा कामकाज देखते हैं। मोहन लाल पाठक ने मेरा इकरारनामा प्रदर्श लिखा। मुझे याद नहीं कि इकरारनामा का जिक्र मैंने बयान तहरीर दैट इज WS में किया है अथवा नहीं। मैं अपने नोटिस में इकरारनामा का जिक्र नहीं किया है। Even in the notice also it has not been stated that there was a prior agreement in the month of August. जिन्हें प्रदर्श 3 में मैंने किराया वादी रहने की बात का जिक्र नहीं किया है। मेरे अधिवक्ता मोहन लाल पाठक अभी दिनेश्वर पाठक के अधिवक्ता हैं। सादा कागज में किराया लिखते हैं। इस बात को मेरे दादा ने सितंबर 82 में बताया। Naresh Pathak. He is the father of defendant number 3. पैराग्राफ 4 से ऊपर। बाद में मुझे पता चला कि कुछ किराया कागज वाली ने लिखवाया है। प्रदर्श टीम को देखकर कहते हैं कि ये नोटिस को हमने किया था। मकान खाली करने के संबंध में हमने एक पार्टीशन सूट दायर किया है। जुगल किशोर को किराएदार को खाली नहीं कराया, इसलिए हमने उस पर बंटवारा वाद दायर किया था। Now Lordship says what he says. Since किराएदार को खाली नहीं करवाया जुगल किशोर, तो हम लोगों ने उन पे बंटवारा वाद कर दिया अपने फादर। जुगल किशोर ने प्राथमिक संपत्ति बेचकर इस संपत्ति को हासिल किए हैं। रांची की संपत्ति मेरा भी हिस्सा है और पटौनी छोड़कर भी मेरा हिस्सा है। मुझे शर्मा को किराया नहीं देते थे, मैंने पावर पटौनी नहीं दिखलाया। मैंने मौखिक सच किया, मुझे पावर पटौनी सच हुआ। उसके बाद जो सबसे इम्पोर्टेंट है पैराग्राफ 6, नारायण शर्मा को इकरारनामा
क्यों पढ़ रहे हैं? कितना DW?
DW ये नारायण शर्मा
DW4 पढ़ रहे हैं ना?
जी, नरेश शर्मा DW
ऊपर नीचे लगा।
हाँ, नरेश। अब पैराग्राफ 6 पेज 3 का लास्ट से होता है। मुझे पावर पटौनी देने का इकरारनामा किया गया। इस बारे में मैंने बातचीत नहीं किया। मुझे नहीं पता कि तकरारी
आपका DW मैच नहीं कर
नाम से देखा गया पीछे को। हम नरेश पाठक पढ़
नरेश पाठक।
हाँ, तो पैराग्राफ 4, 5 और 6 इंपॉर्टेंट है। 4 हम पढ़ लिए, 5 भी पढ़ लिए, 6 पढ़ रहे हैं। 6 इंपॉर्टेंट। मुझे पावर पटौनी 6 जो पेज 3 का लास्ट से
लास्ट हाँ।
मुझे पावर पटौनी देने के साथ इकरारनामा है। इसके बारे में मैंने भी बातचीत नहीं किया। मुझे याद नहीं पड़ रहा कि तकरारी संपत्ति को बेचकर मेरे लड़के ने मेरे साथ पिताजी के ऊपर मुकदमा किए थे। नारायण शर्मा के इकरारनामा के संबंध में मैंने लड़के से बातचीत नहीं की थी। नारायण शर्मा के इकरारनामा पर मुकदमा पूरा नहीं कर सकता हूँ। इस मुकदमा के बारे में होने पर हमने पिताजी से बातचीत किया। पिताजी ने मुझे कुछ नहीं बताया कि उसने शर्मा से इकरारनामा किया कि नहीं। मुताले के बारे में पिताजी को जानकारी है। 2 वर्ष पहले मेरे पिताजी से इस विषय मुकदमा के विषय में बातचीत की थी। मेरे पिताजी बहुत जगह रहते हैं। वे गया भी जाते हैं, हजारीबाग भी जाते हैं। अभी मेरे पिताजी चतरा गया चले गए हैं। चतरा से वे बस में ही आना जाना करते। This was again deposed in the year 1987. He was healthy, hearty, आँख भी ठीक था, पैर भी ठीक था, खुद ट्रेवल करते थे बस में। And his own son was deposing for his father.
Okay. What else?
No. अब ये जो बस एक पैराग्राफ तो पढ़ें। ये दिनेश्वर पाठक, यहाँ पे डिपोजिशन नंबर 3 लिखा हुआ है। डिपेंड नंबर 2 की तरफ से इज डिपेंड नंबर 2 दिनेश्वर पाठक। इनके पैराग्राफ 4 का लास्ट में हाउ दे आर ट्राइंग टू मिसलीड द कोर्ट। जुगल किशोर पाठक से इकरारनामा लिखा लिया है, हमारे बारे में कह रहे हैं। जुगल किशोर बूढ़े हैं, वे ठीक से नहीं सुनते हैं, उनकी मानसिक स्थिति भी खराब है। That is just before paragraph 5. Again, same repetition in paragraph 8. अप्रैल 82 में जुगल किशोर पाठक की मानसिक स्थिति ठीक नहीं सॉरी ये हमारे फेवर में था। अप्रैल 1982 में जुगल किशोर पाठक की मानसिक स्थिति ठीक थी। On the after his deposit about his home, I just only by this lordship I just wanted to show the conduct that how he is dealing with the mental status of the person who has already executed a sin deed.
These aspects have been taken into consideration by the courts.
Yes, Lord. Now, Lord, the exhibits which they have notice which has been given to us by them. That this is Lord's exhibit 3 by 1. The notice dated 20/11/1982 by Ramkinder Party Defend number 3.
Yes.
That my client is the grandson of Sri Jugal Kishore Pathak, Kokar such and such, and also holder of the power of attorney executed and registered by his grandfather to do all for his and his name on his behalf to do certain acts, deeds, and things in connection with his house property at Kokar, Chowk, HP Road, Ranchi, to save the mismanagement of his property because his grandfather Sri Jugal Kishore Pathak is an old aged man of 100 years, mentally and physically not to act in right way. That my client came to know that on 20/9/82 इसको इम्पोर्टेंट है क्योंकि आगे कहते हैं कि हमको जानकारी नहीं। This 20/9/82 that you have made an agreement for sale for his shop under ward number such and such, dated such and such. That on behalf of my client, I have informed you on 20/9/82 that Shri Jigar Kishore Pathak, grandfather of my client, is not in a position to act or work in a right legal way due to his oldness. So, if it is true that your agreement will be declared null and void, and the heirs of Shri Jigar Kishore Pathak will no responsibility for this because there is no any urgent need for any necessities for his family. This is very important, Rash. No responsibility because there is no any urgent need or any necessities of the family at present for the money. This is Lordship the entire contradiction from his WS, not in WS because he has not stated anything, in his deposition. In deposition, Lordship in paragraph 11, he says, पैसों की जरूरत थी इसलिए दिनेश्वर पाठक को बेचने की जरूरत पड़ी. And here this is no urgent need of money. It is in the notice. But he did not inform me or my client up till now about this 20th day of November 1952. That I request you not to make any agreement with any respectable, that respectable old man. And if it had been done by you, my client is ready to consider this matter. That for the sake of natural justice, please confirm and settle the matter peacefully before 23rd day of November 1980. When this was not materialized, therefore the sale deed was executed and thereafter the entire thing happened. By this time, even in this notice, Lordship, he does not say that he has made any agreement. Rather, he says that we are not in the need of money.
And this is dated 2011-82.
Yes.
And sale date is dated?
Sale date, Your Worship.
In the month of December, I think.
हाँ दिसंबर का 11-12 दिसंबर 10 दिसंबर कितना हाँ 20-12 एक महीना पहले नोटिस दिए हैं उसमें कहते हैं कि पैसे की आवश्यकता नहीं है बट ये एग्रीमेंट बन गया है जो 20-8-82 को है
No mention of agreement.
yes but rather उल्टा कहते हैं कि हम पैसे की आवश्यकता नहीं है हम उसको नहीं बेचेंगे वो ओल्ड मैन है वो गलत कर रहे हैं तो आप उनका साथ मत दीजिए और हमसे डिस्प्यूट को सेटल कीजिए और हमको बताइए इतने तारीख तक क्या करना है जब ये कुछ नहीं होता है तो अपने बहनों को बेच देते हैं अपने फूफा को और उसके बाद हम जब सूट करते हैं तो सूट में सारा कुछ आ जाता है वो सेल डीड में लिखते जरूर है ये एक एग्रीमेंट फला तारीख को हुआ था उसके आधार पर हम इसको बेचते हैं
So these aspects of the matter have been discussed by the court.
Yes, not in that detail also. I must say not in that detail, but because both the courts have understood the conduct of the defendants, and therefore it was very easier for them. It is always easier, Lordship, for the court when the person who is. I was reading a judgment, Lordship. It was categorically stating that a person who is the vendor does not come before the court. Strong adverse inference is to be derived if he is alive, neither is deposed. The exact Lordship on that I will also be giving you. Now, by this Lordship, I am confining my this argument on point number 1. Now, the second substantial question of law, Lordship, it is also somehow covered.
What is the second one?
With respect to defendant number 2, that is whether the oral agreement dated 20-8-82 Exhibit B, executed by defendant number 3, earlier, in oral earlier भी नहीं खाली agreement, whether the agreement dated 20-8-82 Exhibit B, executed by defendant number 3, as constituted attorney of defendant number 1, shall prevail upon the subsequent agreement dated 18-9-1982. Now, for this Lordship, already we have shown that there was no such existence of the agreement. By the statement of the parties, from the WS, from the notice, it only comes in the WS, in the deposition of defendant number 3, not in his WS. Nothing of such is there in his notice. We have just read that. And moreover, no such issue was framed by the trial court. Neither it was pressed at any time. Even in the appellate stage also the issue was not recasted.
Whether he is a purchaser, bona fide purchaser. No such issue was framed.
No such. He was there. He has filed his WS. That was the first point could have been formulated by the trial court. The two agreements are there, which should prevail. Had the agreement of 18-9-82, that is, sorry, the Exhibit B 28-82 had been there. Suppose if a person who is doing agreement with someone else, and thereafter he is again doing agreement, then Lordship, certainly the previous agreement will prevail. Nothing is required to be decided. But this was the main and core issue. Why they were shying away from getting this issue framed? अगर ये issue frame होता तो threadbare analysis होता, everything would have come out. And this is also hit by the amendment of the issue. The issue was abandoned. And now they want that this is a issue purely a factual issue should be decided by the Honorable High Court. It is entirely a factual issue. Whether there was a agreement or not, had there been an agreement, if it all accepted by the court, certainly which agreement will prevail. It is a pure question of fact. Therefore, I am also confining my points on this because since nothing is there in the WS of defendant number 3, nor defendant number 1 has come to depose or file his WS, and nothing is there in the notice given by defendant number 3, who is the power of attorney and holder is given the agreement. Therefore, this issue is required to decide in favor of them.
That's all.
And now the third point also, Lordship, the agreement which whether the receipt or the extension of time of the agreement is specific performance of contract marked XB 2/1 was inadmissible address for the same not being duly stamped. I have already stated it will not have much bearing on the case. Had it not been accepted, even if it is decided in favor of the defendants, it will not have any bearing since my right to sue was there. It was within the time of limitation. We have shown that the 2000 was paid. No one was there to controvert the same. The signature has been admitted. This is 2011 paragraph 16 on the stamp act.
2011.
2006 volume 11 SCC 331 paragraph 16.
Para number?
16. Said decision therefore is an authority for the proposition of section 36 to operate even if the document has been improperly admitted in evidence. It is a trial or of no consequences as to whether a document has been admitted in evidence on determination of a question as regard to the admissibility. Therefore, or upon dispensation of the formal proof therefore, a party to the list intends that an instrument produced by the other party being insufficiently stamped should not be admitted and he must raise an objection thereto at the appropriate stage. He may not do so only for it at his peril. Mr. Constable. Give it to see. That is such.
No objection was taken.
They say that the objection was stamped. I could not find from the exhibit, but
हाँ नहीं अब उसको नहीं करे तो ऑब्जेक्शन हम लिए थे लेकिन वहाँ स्टैम्प पे आया था कि रसीद इन्होंने कहा हमारा रसीद भुला गया था और उस पर हमने कहा कि एडवांस इंफॉर्मेशन लेना चाहिए कोर्ट ने कहा कि मैं एडवांस इंफॉर्मेशन नहीं ली क्योंकि प्लीडिंग में ये बात नहीं थी कि रसीद इनका खो गया है गवाही में एक बात आई कि जिस दिन रसीद बना था तो पूरा पेंडोरा बॉक्स हमको फिर से ओपन करना पड़ेगा उसमें क्वेश्चन ये आया था कि जिस दिन एक्सटेंशन ऑफ टाइम का बात हो रहा था वहां पर एग्रीमेंट नहीं था एक सेपरेट कागज में रसीद बना था प्लेंटिफ ने अपने गवाही में कहा और काशीनाथ साहू जो उनका वकील है वो भी यही गवाही की एक सेपरेट कागज में रसीद बना था लेकिन वो भुतला गया बट दिस इज नॉट इन द प्लीडिंग तो पता नहीं वो रसीद क्या था नहीं था भुला
वो तो
गया
एग्जिबिट भी नहीं हुआ आया ही नहीं उसका कोई रेलेवेंस ही नहीं
उसके जगह ये सब्स्टिट्यूटेड क्योंकि एग्रीमेंट वहां था नहीं तो उसके पीछे लिखता कैसे लिखने की कोई बात ही नहीं थी और अगर एग्जिबिट 2/1 को देखा जाए ना तो बाकी एग्जिबिट से खाली उसका सिग्नेचर को अगर खाली एक बार
ये तो बोल रहे एग्जिबिट 2/1 नहीं भी कंसीडर होगा तो कोई
तो रसीद है ना वो एक्सटेंशन ऑफ टाइम नहीं है उसमें लिखा रिसीव्ड रुपीस इतना देखा जाए हां रिसीव्ड लिखा एंड रिसीव्ड का डेफिनेशन अंडर सेक्शन 223 ऑफ द स्टैम्प एक्ट says that any instrument ठीक है, दैट इज एक्सटेंशन एस्पेक्ट पर आप मानिए कि एक्सटेंशन हो गया, लेकिन रसीद है ना, वो रिसीव नोटिस लिखा है ना, रिसीव का डेफिनेशन है ना कानून में, a memorandum in which the acknowledgement is made of receiving a money is a receipt under section 2 subsection 23 of the Stamp Act, and irrespective of the objections, para 30 of the 2024 volume 7 SCC, which I had referred to yesterday, GM Sabul Hamid, in para 30 says that there is, yes,
It has to be considered. बोलिए
दिए हैं,
दे तो दिए हैं, कल नोट भी कर दिए
नहीं उसमें पैरा 30 नहीं,
आप पढ़ लिए
नहीं पैरा 30 नहीं बोले थे, अभी कह रहे हैं कि ऑब्जेक्शन नहीं किया, तो उसमें बोलता है कि the legislature has imposed the responsibility on the courts to and trusted them to ensure that the requisite stamp duty along with the penalty is duly paid unstamped insufficiently stamped instrument placed on admission in support of the case of party. It is incumbent on the courts to afford the sanctity of the legal framework governing stamp duty. At the same time, it is crucial authenticity enforceability of the instrument, allowing instrument with insufficient stamp duty to pass a challenge merely due to technicality would undermine the legislative intent and fiscal interest of the state. The courts to ensure the compliance with all substantive and procedural requirements of the This is another aspect, like एक interesting aspect हमको देख रहा था, ये जो कह रहे थे कि डिफेंडेंट नंबर 2 का गवाही है, तो हमारा तो कंटेंशन शुरू से ही रहा है, ये लोग दोनों हैंड इन ग्लव्स हैं, और संभव और कि अगर बड़ा आदमी का प्रॉपर्टी को लेना है, चाहे ये ले चाहे वो ले, लेना है किसी न किसी को लेना है, हम नहीं स्वीकार किया भैया, पावर बटन नहीं, हम नहीं, हमारा ये कहना है कि जो भी है क्वेश्चन ऑफ लॉ ये था कि परवर्सिटी है कि नहीं, कंकरेंट फुट का फाइंडिंग उसमें पैरा 34 to 36 of the decision reported in 2024 volume 11 SCC page 351 रमाकांत चौकसी, ये वाला डिसीजन का नहीं है 24/11 SCC रमाकांत चौकसी पैरा 34 to 36 परवर्सिटी को उसमें क्या, और उसमें एक ही लाइन मुझे सबसे इंटरेस्टिंग लगा, इट्स अ कॉमन मैन्स असेसमेंट of the state of affairs. If a common man cannot come to such a conclusion, and such a conclusion has been given by the court, that a man who lives at Jalibag, इनका जो विटनेस है ना, कहता है कि रांची आए थे, उनका विटनेस का एड्रेस देखा जाए DW, नरेश पाठक रहता था हजारीबाग, तो रांची में पता नहीं कौन सा चश्मा देख रहा था कि रांची आए, अब तो हम थे ही नहीं, तो जो खेला होना था सुबह DW का एड्रेस है गवाही में हजारीबाग का, वहीं से देख लेता था बेचारा, दूरदृष्टि थी, रांची में हम आए थे, सितंबर में आए थे, नवंबर में आए, बड़ा इंटरेस्टिंग, अरे भैया मेरा पर्सेसर नहीं है, ये परिवार में जो भी हो, लाइन से प्रॉपर्टी है, कहीं पर भी है, जो है कहना चाहिए, जो ऑर्डर करना है,
आर्गुमेंट्स
एक रिक्वेस्ट था, समाप्त हो गया है, ऑर्डर के लिए रखे जाए 2-3 पेज का
आप 3 पेज का कुछ नहीं बना सकते,
ठीक, हम खाली चाह रहे थे कि पॉइंट्स वही दे देंगे, हम भी इनको दे देंगे, ईवीएम को दे देंगे, डायरेक्शंस को
हम ऑर्डर रिजर्व ऑर्डर में नहीं रखेंगे, हम ऑर्डर रिजर्व कर रहे हैं, आप कल तक दे दीजिएगा तो ठीक है, उसके बाद नहीं देना,
हम शाम
ना आपको देने देंगे ना उनको देने देंगे, और रजिस्ट्री में तो बोल दीजिएगा कि कुछ भी नहीं लेंगे, कल तक अगर आ गया तो आप ले लीजिए, ये तो कुछ लेने का जरूरत नहीं, आप 2 पन्ना बोले हैं, 2 पन्ना को याद रखिए,
एकदम judgment on site case 2004 Andhra Pradesh 110 that I am filing
प्लेस करिए, खाली फाइलिंग से नहीं होता, प्लेस करिए जजमेंट। 2004
थोड़ा सा बीच में कोर्ट में
हाँ आप जाइए। 2004 आंध्र प्रदेश
पेज
110
110
किस पॉइंट पे प्लेस करना है?
which of the agreement will be
paragraph 12.
implemented? Mere execution of document ipso facto does not lead to automatic conclusion that the transaction are genuine, bona fide and reliable. It is the treaty to say that the burden lies on the plaintiff to establish his case because deficiencies or weakness on the part of the defense. But when six defendants tried to project a real document to claim primary and priority over the latter document, the burden shifts on six defendants to establish that the genuineness of document exhibit B1. It is also settled condition that amongst two each document, one which is a real in point of time has to be preferred provided transaction and payables.
और उनको भी बोल दीजिएगा जो कोर्ट में बहस किए हैं उसके अलावा एक भी शब्द रिटन सबमिशन में नहीं रहना चाहिए। रिटन सबमिशन इज ओनली फॉर द मेमोरी ऑफ द कोर्ट। और नया कहानी नया जजमेंट देंगे तो यही लिखेंगे हम जजमेंट में रिटन सबमिशन में नया चीज प्लेस किए हैं, सो दिस रिटन सबमिशन इज रिजेक्टेड। प्लीज डू नॉट डू दिस। आई हैव हर्ड यू एट लेंथ और ये सब नया कहानी नया जजमेंट मत दीजिए, ठीक है? आर्गुमेंट्स कंक्लूडेड। The counsel for the parties have undertaken to submit short synopsis running into 2 or 3 pages maximum, latest by tomorrow, failing which the written submissions will not be accepted.
The power of attorney and the people.
हो गया
They
सर,
have
आपको
concurrent power.
अब आप एडवोकेट्स का काम खत्म हो गया। ये साफ रखिए। ये रेस्पोंडेंट का है, उसको नीचे रखिए। सेवेंटी एडजर्नमेंट्स हो चुका है इस केस में। मोस्ट ऑफ द टाइम आप ही लोग के इंस्टेंस में है।
Two sets of applicants.
अभी तो आप लोग 5-10 और एडजर्नमेंट लेने के लिए इसको जरा खोल के देखिए। इसको निकालना है, इस इसको इसके साथ रखना है तो सारा का सारा एक साथ टैग इसके साथ टैग रखना है कंप्लीट। ठीक, हाँ इसको निकाल के उसके साथ जजमेंट के साथ साथ ये कल स्टैम्प स्पेसिफिक
From the daily list, under heading for final disposal, text is item 1, 2nd April, 88/1984.
There is no impact of abatement.
Appellants are the plaintiff, then respondent, then plaintiff's suit has been decreed, then defendant has filed the assertion, which has been allowed. It is accepted. Well, the fact of the case, my lord, one Ganesh Mahato married with one Dirsi. That time Dirsi had already two child from her previous husband.
Nirsi, NIRSI.
That time Dirsi had already two children, two sons from her previous husband. Those are Budhan and Maja. Those are the defendant number 1 and 2.
Two sons from previous husband.
Budhan and Maja, those are the defendant number 1 and 2. Original defendant number 1 and 2. And from the wedlock of Ganesh Mahato and Dirsi, plaintiff has won. This is admitted case. Therefore, there is no blood relation between the plaintiff and the defendant number 1.
No blood relation.
Yes.
Mother is the same.
Yes, same. Therefore, my lord, says Hindu succession law, my lord.
So there is blood relation.
Defined किया है, my lord. Defined किया है. Section 2 को देखते हैं, my lord. 3 type of relation: full blood, half blood.
Section 2. Yes. Which subsection? One person is said to be a cognate of another if two are related by blood or adoption but not wholly through means.
E, my lord. 3 and section 3 E.
ये उसके पहले सी भी पढ़ी.
C. Cognate. One person is said to be a cognate of another if the two are related by blood or adoption but not only through means. And kindly see the E, my lord. More described, my lord. Full blood, half blood, and uterine blood. My case is plaintiff and defendant number 1 and 2 are related by uterine blood. Definition of uterine blood is, my lord, two persons are said to be related to each other by uterine blood when they are descended from a common ancestors but by different husbands. And then, my lord, section 8, my lord, of the Hindu Succession Act.
Yes. Section 11.
Section 8, my lord.
Section
8 of the Hindu Succession Act.
When did the marriage take place? Prior to 1956?
Yes.
Section 8.
General rules of succession in the case of males. The property of a male Hindu dying intestate shall be given according to the provision of this chapter. Partly upon the years being related specified in class 1 of the schedule. Under 10, kindly see the schedule.
Uterine blood is not there. And then class 2. Class 2.
Class 2. Class 2 में भी उस लिखा हुआ है same चीज.
So you are claiming as son of, you are claiming the property as son of Ganesh and
Ganesh Mata and the defendant number 1.
the property belongs to Ganesh.
Ganesh. In the first schedule, my lord, in the bottom it has been mentioned that in this schedule, reference to a brother or sister do not include reference to a brother or sister by uterine blood. That has been clearly defined. Therefore, it is also the finding of the learned court below. Appellate court below has not reversed that finding. By law, they are not entitled. Appellate court finding of the appellate court below is the same. They have not changed the finding.
Why have they, what was the suit for declaration of title?
No, madam. First year, we declare that sales that is 21-73 and 7576 executed by defendant number 1 and 2 in favor of defendant number 3 are illegal and void and not binding.
So you want to say that they did not have the title?
Yes. And that is also the finding of the learned court.
So what is the substantial question of law?
Order dated 8/7/96, order number 24. Whether the suit in the present form or declaration is having any question related to the adverse possession as claimed from the side of defendant number 1 and 2. And secondly, whether the plaintiff suit suffered due to his non-finding of declaration against the defendant number 1 and 2, challenging the Batwarnama of 1946 or the attainment of his majority within 3 years from 1990.
So whatever you have said has nothing to do with this substantial question of law?
No, I am stating the fact, my lord. And now, my lord, it is second law that regarding the first question, the substantial question of law, regarding the adverse possession.
अच्छा एक सेकंड essay number 88 of 1984. The learned counsel for the parties have jointly submitted that so far as deceased persons involved in this case are concerned, the same shall not have any impact in the present case and therefore the appeal is not awaited. The counsel for the appellant has submitted that the appellants are the plaintiff. They were sole appellant. The The suit was filed by sole plaintiff, and the appellants are the legal heirs of the sole plaintiff. The suit was decreed. The first appellate court has reversed the decree, and consequently, the second appeal has been filed by the appellants. We submit that it is not in dispute that Ganesh Mehto, the plaintiff, married Nirsi, Nirsi, who had 2 sons from her previous husband. Ganesh Mehto was the plaintiff, and the 2 sons from previous husband were defendant number 1 and 2.
गणेश माधव प्लेंटिफ
गणेश
victim उनका लड़का
उनका लड़का
अच्छा
जो निर्सी के साथ सादा बात हो
sorry. The plaintiff was born out of wedlock of Ganesh and Nirsi, namely Bhakti Mehta. He has submitted that the defendant number 1 and 2 executed 2 sale deeds in favor of defendant number 3. Although they did not have any title over the property belonging to Ganesh Mehta. He has referred to the provision of Section 2E of Hindu Succession Act and submits that the plaintiff and the defendant number 1 and 2 were related by uterine blood. And then he has referred to Section 8 with respect dealing with succession of property belonging to male. He then referred to the schedule and submits that the schedule specifically exclude children, brothers, specifically excludes reference to brother or sister who are related by uterine blood. The learned counsel submits that the consequence is that the property of Ganesh Mehto would devolve exclusively upon the plaintiff and not in favor of the defendant number 1 and 2, and consequently the defendant number 1 and 2 had no right over the property to convey through sale deed. He submits that the sale deed executed by defendant number 1 and 2 in favor of defendant number 3 were under challenge before the learned counsel. The learned counsel has then referred to the substantial question of law framed by this court by the order dated 8/7/1996, which are as follows.
kindly consider matter. That matter, London court has decreed the suit, and by giving finding that defendant number 1 2 has no right title over the property, therefore sale deed is void and non-binding on the plaintiff. Thereafter, minor appeal has been filed. Appeal has been allowed on the ground of limitation that 2 sale deeds are one is of 1973 and one is of 1976, and suit has been filed in the year 1980. Therefore, as per Article 60 of the Limitation Act, limitation during 3 years. Therefore,
1973 and
1976. Therefore, suit is barred by limitation. This point has been already discussed by the London Trial Court panel, and London Trial Court has rejected that plea by applying the Article 65 of the Limitation Act.
this appellate court has referred to Article 59.
60.
Appellate court.
Yes, 60.
59.
59, 60.
59 and 60. And the trial court had applied 65.
65.
Appellate court have applied Article 58 and 60. Appellate court. And trial court have gone into Article 65.
But there is no substantial question of law on that.
And now, my lord, first substantial question of law. That is the
See, if there is no substantial question of law on the point of limitation, what is the big idea of answering the other substantial question? If the suit is barred by limitation, matter ends there. You may have very good merit. You may have many good merit. A suit which is barred by limitation, it goes.
My submission is my lord. That is not barred by the limitation.
No, that is not the substantial question.
There is as per CPC, my lord has
No, I will not. No, there is no petition on record. What do you mean? That I will do it so moto. I will not do it so moto. I will not do it so. Why should I do it so moto?
Actually, my lord, kindly consider, my lord. This appeal has been virtually allowed on the basis of adverse possession.
So
That is available in the substantial portion of
let's see. Let's see. If it has been allowed on the point of adverse possession, then we'll see what is the impact.
Yes, that is my lord on the ground of adverse possession.
If it is on the point of adverse possession, then again referable to section 65, article 65.
My lord, their claim is on the basis of partition deed. It is settled law that a person cannot claim a property on the basis of any deed and simultaneously on the basis of adverse possession, because those are inconsistent with each other. कोई भी डीड के बेसिस में या कोई डॉक्यूमेंट के बेसिस में यदि टाइटल क्लेम करते हैं, फिर साथ में एडवर्स पोजीशन से ये क्लेम करते हैं, तो मेंटेनेबल नहीं है. And in this case, my lord, kindly see their written statement. They mainly based on the plea that they have got the title on the basis of partition deed, and only one paragraph they have mentioned that suit is also not maintainable on the basis of adverse possession. For adverse possession, my lord, it is for the defendant, it is required that they
Even if it is held that the defendant did not have any adverse possession, then also limitation is stating it. The suit being barred by limitation is stating it.
there is a judgment in this point, my lord. If any suit has been filed for confirmation and possession for the primary relief and ancillary relief to declare the sale deed as void or any document as void, then 12-year limitation is applicable, my lord. That is the Article 65.
That is not the question of law.
My lord, there is judgment, my lord. My lord, it, recent judgment, my lord, may be permitted to show, my lord. It has been admitted earlier, my lord, but this point, law point is available, my lord.
ऐसे नहीं हो सकता ना, हम सब्सटेंशियल क्वेश्चन ऑफ लॉ के बाहर एक शब्द नहीं सुनते.
CPC permit किया है, my lord, at the time of argument, if any substantial law, my lord has think that it is required to frame, then my lord is.
Then what are you doing for last 10, 12, 15 days? What is this? No, you have not filed any petition. I will not frame it like this because I have to hear them also.
Substitution petition has not been allowed.
So,
Now why are you
बहुत अच्छा बात है. 84 का सूट लेकर अपील लेके बैठे हुए हैं हम लोग. ये सब कुछ नहीं. आप अपना सब्सटेंशियल क्वेश्चन ऑफ लॉ पे फोकस करिए और अपना आर्गुमेंट कंक्लूड करिए. This we will not permit. What is this? There has to be some fighters.
CPC permit कर रहा है, my lord.
CPC permit कर रहा है. I am not satisfied with that. You see, there is also a provision that you have to file an interlocutory application. Every day it is being filed over here. They have a right to respond. They have the right to go through it. ऐसा थोड़ी होता है कि हम अपने मन से substantial question of law. I am not going to frame any such substantial question. Why should I frame?
लॉ पॉइंट जो है जजमेंट से एकदम क्लियर हो जाता है कि अपने को गलत किया है, मतलब उसको माइनर को देखने
हम अपना जो बना है उसके बियॉन्ड कुछ नहीं देखेंगे.
तो फिर माइनर एडवर्स पोजीशन का देख ले, उनका कोई प्लीडिंग नहीं है. Adverse possession minor, first is minor, they should accept that plaintiff is the owner of the property. They have not accepted minor. First principle has not been followed. From which date the defendant number 1, 2 have been in possession of the property adversely, that has not been mentioned minor. Therefore, minor, defendant virtually failed to prove the plea of adverse possession. Without any pleading minor, landed appellate court has allowed the appeal on the ground of adverse possession. If you permitted to read the
No foundation pleading of adverse
adverse possession. Only a general statement. This suit is barred by adverse possession. And entire written statement based on the
No date of possession.
no date of possession, no acceptance of proof on it. They have not accepted that plaintiff is the owner of the suit property. They have not accepted. That is the main point of adverse possession. And may be permitted to read the written statement, madam.
Only a bad statement that the suit is. Which paragraph is that?
Paragraph 5 of the document.
Yes.
That defendants have perfected the title by adverse possession.
Paragraph 5 of the document only says that the suit is further barred by law of adverse possession since the suit land was firstly in cultivating possession of defendant number 1 and 2 and then came in physical possession of defendant number 3 in the year 1973 and since then it has been coming in continuous physical possession. This is what so far as adverse possession.
And entire W is based on
The
the
foundation pleading is not there.
No, brother, I don't see this. I only see this not what has happened in this case that we will see who is the mother of both different plaintiff and defendant number 1 and 2 have executed a registered deed of partition in between plaintiff and defendant number 1 and 2 in the year 1946.
We'll come to that.
Yes.
What I am saying is
Yes.
that so far as adverse possession is concerned, the foundation
No,
pleading is not
I
there.
don't dispute this.
Okay, so first substantial question of law goes.
It goes definitely.
Okay, आपका first substantial question of law. देखिए. The learned, with respect to the first substantial question of law, the learned counsel for the appellant has submitted that on the face of the written statement, the foundational pleading in connection with adverse possession is totally missing. He submits that mere mention of adverse possession in the written statement is not sufficient, and the foundational pleading should contain the date of possession and also acceptance of the true owner. He submits that these aspects having been missing, the first appellate court could not have given a finding in favor of the respondent so far as adverse possession is concerned. He has submitted that the suit was filed inter alia challenging the sale deeds.
not only for declaration that it is not binding upon the plaintiff. It is quite illegal.
He submits that suit was filed
And for confirmation of possession.
for a declaration that the sale deeds executed by defendant number 1 and 2 in favor of defendant number 3 was not binding and it was void and illegal.
And also for confirmation of
And also for confirmation of possession. The learned counsel for the respondent does not dispute that the foundational plea in connection with adverse possession is totally absent in the written statement.
But only indicate what I am defendant number 4 and 5.
And how are you related to defendant number 3?
Not the Lordship has recorded my statement. Earlier they have given me Wakalatnama, but they have taken NOC from me. But that statement is already there.
The council is representing defendant number
4 and 5.
4 and 5. And as already recorded earlier, he had received Wakalatnama, 5 Wakalatnama on behalf of the legal years of respondent number 3.
The Lordship may say not defendant number 3.
Okay,
Defendant number 3.
defendant number 3, but they have taken no objection from him and no fresh Wakalatnama has been filed in the proceedings.
Adverse possession.
ऊपर लिखिएगा appellant has relied upon the following judgments on the point of adverse possession. Bracket 2004, bracket close 10 SCC 779. उसके पहले लिखेंगे 1995 volume 2 SCC 543. And then third one is bracket 2006, bracket close 7 SCC 570.
The second substantial was not done. Whether the plaintiffs will be suffered due to his non-filing of DTS against the defendant number 1 and due to challenging the Wakalatnama of 1946 on attainment of his majority within 3 years after 1950. My lord, partition is not a transfer deed. Partition not create any title. Only it distribute the property between the title holders. इसमें मान लो 3 years का जो limitation है, it is not applicable. It is applicable if property has been transferred. Minor's property has been transferred by his guardian. Then it is required to challenge that sale deed within 3 years from the date of majority. But partition deed is not create a title, therefore it is not a transfer deed. Therefore, it is not required to challenge the partition deed within 3 years. सिक्सटी को देखते हैं लिमिटेशन एक्ट 60 1960 आर्टिकल 60 इसमें लैंग्वेज क्लियर है
At this time, we have the time for order 41 rule. With respect to second substantial question of law, the Learned Counsel has submitted that the registered deed of partition that the deed of partition is not a document of transfer, but it only distributes property amongst title holders. He submits that in a case where the property is alienated, property of a minor is alienated, then only the question of challenging the same within 3 years of attaining majority applies. He submits that since partition is not transfer, the partition deed dealing with the property which did not belong to the defendant number 1 and 2 is of no consequence, and the same was not required to be challenged at all. He has referred to Article 60 of the Limitation Act. The arguments have remained inconclusive. Post for further hearing.
From the supplementary list and the heading for hearing under Order 41 Rule 11 of CPC, Item 8, Second Appeal 64 of 2023.
Number 90 of 2026. On this title, we will find out as the lesson of this safety number 216 of 2026, dated 7 January 2026.
Yes.
I am reading the second paragraph.
Second paragraph.
The brief story of the present shows that the smooth land and the total area of 30 out of 2.97 acres of the land, being the portion of plot number 238, khata number 1, village Jamardaha, PS Dande, with the specific boundary as described in the schedule of the plan, was recorded during the last survey of the settlement of this in the name of Mercy Prasad Singh, grandfather of this land, who was in possession of this project land. But after 2 years of this survey, Mercy Prasad Singh died, leaving behind his son, Naval Kishore Prasad Singh, who succeeded this said property and came in possession of it. It is further stated that he said Naval Kishore Prasad Singh had constituted a joint Hindu family governed by the Akshara school of Hindu law, consisting of himself, his two sons, Rohit Kumar Singh and Ganesh Prasad Singh, plainly, and their respective sons of which Naval Kishore Prasad Singh was the Karta, who all were granted possession of the land of Khata number 1, including 2.97 acre of land of the plot number 2, 3, 28. Subsequently said, Naval Kishore Prasad Singh died in the year 1940. He said, he estate of the witness living behind his two sons, Nelson Edward, The grandson, namely Rajendra Prasad Singh, son of Rohit Kumar Singh, and Ghanshyam Singh, Takeshwar Singh, Shankar Singh, all sons of Ganesh Prasad Singh, who jointly succeed of the property by rule of survivors after Rohit Kumar Singh and his son Rajendra Prasad Singh and his three sons Ghanshyam Singh, Takeshwar Singh, and Shankar Singh. On the other hand, amicably partition the land of Khata number 1 of the village Jabardaha in two equal shares. Each of them came in possession of their respective half share accordingly. The land has been amicably partitioned, and it has also come in the written statement of the defendant.
So,
Lordship,
you read further. The plaintiff stated that
it is further stated that the plot number 328 area about 2.97 acres, each got 1.5 acres in their share and their possession over it. After the said proportion, Ganesh Prasad Singh, the plaintiff and his three sons, namely Ganesh Singh, Takeshwar Singh, Shankar Singh, Vastikarta, and each of them have got their undivided one-fourth share in the land of the joint family. Thus, they got 37 decimal each in their share. However, it was not joint possession of the land. It has not been partitioned among them. The plaintiff further stated that after he became old of about 80 years, old man and getting ill, resulted in physical handicap. He was unable to walk off his leg. Hence, his oldest son, Ghanshyam Singh, became Karta of the joint family, who started looking after the cultivation work and the entire family affairs since the last few years. Three sons of the plaintiff mostly remained out of the village due to their work. The husband of the defendant, namely Nandlal Ramani Vajpayee Sir, and the dishonest man who with an intention to grab the land of the plaintiff and his sons played for him and brought Amar Singh, plaintiff's son-in-law, in his collusion after elopement, and then the defendant husband and Amar Singh on the 7th January 2006, when all the plaintiff's sons were out of the village, managed to bring the plaintiff to Britain on the false pretext of his treatment by practicing fraud. What a registered sale dated 7th January 2006 executed in favor of the defendant with respect to 30 decimal of land in plot number 389. Thana number 1 of the village Jabardaha, yes, Gandhi, which is the suit land, only described in the schedule of the property. The plaintiff further stated that there was absolutely no transfer between the plaintiff and the defendant on her husband, nor any consideration money was paid by the defendant, her husband, to the plaintiff for the transfer of the suit land in their favor. The plaintiff further stated that as he is physically handicapped and was ill about 18 years old, he never agreed to transfer the suit land to the defendant, nor he received any consideration in it. But the defendant and her husband said Amar Singh
what were the issues?
Issues. This was on 44 also. Issue number 5 and 6. This is the registered sale deed dated 216 of 2006 dated 7th January 2000 executed by the plaintiff by way of fraud and misrepresentation. We and therefore wrong, unsolved, illegal, without consideration, hence null and void. And second is the plaintiff entitled for confirmation of the person over the suit land.
So, what is the finding? What is the finding?
Finding is lordship all the lordship on 49 lordship, page number 49 lordship.
Issue number 5 has been decided in
Against the plaintiff lordship.
against the plaintiff.
And 6 is also against the plaintiff, and 1, 2, 3, 4, and 7 is also against the plaintiff lordship.
What happened in the appellate court?
Thereafter, they have filed the appeal on the judgment on 20th May 2017, and they have filed the appeal on the
So there is
61
concurrent finding. What is there? What is there? There is nothing.
Lordship, every party is under. Lordship, kindly see the Hindu Succession Act, Section 6.
No. You see, it is a case of fraudulent execution of a deed.
But
It is a case of fraudulent execution of a deed. Even if a party had title or he did not have title, it makes no difference. If there is a finding that the deed was fraudulently executed, matter ends.
But Lordship, there is no partition between the
Yeah, it doesn't make any difference.
ancestral property and the.
That is not the point. The point is that there is a finding that the deed was fraudulently executed. Essay number 64 of 2023.
Madam, kindly see.
About the learned council appearing
I
on
am relying
behalf
on
of
the
the
judgment of Lordship on and the Supreme Court SSC 2020 volume 9 page 1 on para 135 Lordship and and we relying on the para 137.5 Lordship 137.5 on page 90 also. In view of the rigorous of the provision of the explanation of the section 6 surplus 5 of the Act 1956, the plea of oral partition cannot be accepted as the statutorily recognized mode of the partition effected by a deed of partition duly registered under the provision of Registration Act 1908, effected by the degree of court. However, in the exceptional case where the plea of oral partition is supported by a public document and the partition is finally invested in same manner as if it had been affected by the degree of the court, it may be accepted. A plea of partition based on oral evidence alone cannot be accepted and to be rejected outrightly.
You see, the finding is based on execution of a document fraudulently, isn't it?
But the partition has not been registered, Lordship, and
It doesn't make any difference whether it is registered or not. When there is an allegation of fraud, what else is required? There is a clear allegation of fraud. This judgment does not help you. Irrespective of who has title, who does not have title, it has got no relevance when there is an allegation of fraud.
Lordship, बिना partition के ही अपना बेच दिए उस शेड्यूल लैंड का शेड्यूल भी नहीं बनाई, कहाँ से काटे, कहाँ से बेच दिए। वही एक पार्टीशन का ये तो होना चाहिए था, कोई एग्जीक्यूट नहीं किया गया है। जो भी करवाए हैं, चाहे वो इंटरनेट अपना जितना भी एग्जीक्यूट करवाए हैं, सब अपना शेड्यूल के एग्जीक्यूट करवाए हैं। किसी भी पार्टीशन डील को एग्जीक्यूट नहीं किया है। एवरी पार्टीशन भी होगा तो भी उसको तो एग्जीक्यूट करवाते। किस पार्ट को उठा के बेच दिए हैं, इनका कर भाव करके कहाँ से निकला? 2.97 एकड़ में से ईस्ट वेस्ट नॉर्थ।
You see, you made an allegation of fraud and in various ways which you could not prove.
And you see the page 45 of the Indian title judgment also.
Heard the learned counsel appealing on behalf of the appellant. This appeal has been filed against the judgment and decree dated 4/1/2023, within bracket decree signed on 19/1/2023, bracket close, passed by learned district judge Roman C. DT in civil appeal number 61 of 2017, affirming the judgment and decree dated 25/2017, within bracket decree signed on 3/6/2017, bracket close, passed by learned sub judge Roman C. DT in title suit number 90 of 2006. The plaintiffs are the appellants before this court and have lost in both the courts. After giving the learned counsel for the suit was filed seeking a declaration of registered sale deed number 216 of 2006 dated 7/1/2006 as illegal, without consideration and fraudulent, which was executed by the defendant. The sale deed was executed by whom?
Executed by Lordship Ganesh Prasad Singh.
By the plaintiff.
Lordship.
He challenged his own sale deed.
Yes, Lordship one.
Okay. बस काफी है इतना.
Hindu Succession Act has Lordship section 6 of clause 5 देखी है.
क्या देखें हम इसमें?
उसमें लॉजिक यही कहा गया है कि 20 दिसंबर 2004 से पहले जो भी है ओरिजिन है उसको माना जाएगा, उसके बाद से जितना भी उसको रजिस्टर्ड माना जाएगा.
Okay.
पार्टीशन
Executed by plaintiff in favor of defendant. The learned counsel for the appellant has submitted that there was no partition with respect to the property and oral partition cannot be acknowledged, and he has referred to section 6 within bracket
surplus 5
Five
of
of the Hindu Succession Act and has also referred to the judgment passed by the Honorable Supreme Court in the case of Vinita Sharma versus Rakesh Sharma, reported in bracket 2020, bracket close 9 SCC 1. Paragraph 137.5. To submit that it has been held that a plea of oral partition cannot be accepted as statutorily recognized mode of partition, and therefore the plaintiff did not have any right to execute the sale. Correct? After hearing the learned counsel for the appellant, this court finds that the plaintiff who had executed the registered sale deed number 216 of 2006 dated 7/1/2006 in favor of the defendant had challenged the sale deed, alleging it to be illegal, without consideration and fraudulent. sought a declaration that the plaintiff without any authority, illegally and without jurisdiction, and tainted by fraud and misrepresentation, executed the sale deed in favor of defendant, which is null and void ab initio. The plaintiff also prayed for a confirmation of possession and in the alternative recovery of possession. This court finds that the plaintiff pleaded that the suit land was joint family property and it devolved through survivorship. And the plaintiff was one of the sons of Ganesh Prasad Singh, son of Naval Kishore Prasad Singh. It was also pleaded that there was amicable partition of land of Khata number 1. There was amicable partition of land and plaintiff after partition, the plaintiff and his 3 sons after partition got the undivided 1/4 share of the joint family and were in joint possession of the land. It was also pleaded that plaintiff was old and above 80 years and was physically handicapped, unable to walk, and therefore his oldest son Ghanshyam Singh became Karta of the joint family. The husband of the defendant was a shrewd person who, with an intention to grab the land of the plaintiff and his sons, played foul game and brought plaintiff's son-in-law in collusion under allurement, and then the defendant's husband and plaintiff's son-in-law on 7/1/2006, when all the plaintiff's sons were out of village, managed to bring the plaintiff to Giridi on the false pretext of his treatment, and by practicing fraud got a registered sale deed dated 7/1/2006 executed in favor of the defendant with respect to 30 decimal of land in plot number 398, Khata number 1, which was described in the schedule to the property. It was asserted that there was no absolute transfer. There was absolutely no transfer. No consideration money was paid. And the plaintiff never agreed to transfer the land to the defendant. And the plaintiff was a victim of deep-rooted conspiracy. Amongst his son-in-law and the defendant. And consequently, the plaintiff prayed for a declaration that the CT dated 7/1/2006 was null and void. Written statement was filed opposing the prayer and also the allegations made in the plaint. The defendant admitted that the share was undivided ancestral property of the plaintiff and his sons. And also stated that the plaintiff had not only 37 decimal of land in his share, but he, being the karta and the manager of the family, had full control over the land, and thus absolute owner and manager of the joint Hindu family. And it was denied that the plaintiff was not in a condition to move to the registry office. And the allegation and the sons of the plaintiff were living outside the village, and they had no concern with their father, nor did they provide any financial help to the plaintiff. And the plaintiff had a weak financial condition. And under such circumstances, the property was sold by the plaintiff to the defendant. Upon payment of consideration, the trial court framed the following issues for consideration. And by deciding issue number 5, the trial court considered the materials on record and ultimately held that the plaintiff and also observed that the plaintiff himself was not produced before the court for his examination, nor any medical document regarding paralysis was filed. The court also recorded that the defendant number 1 herself had admitted that on instigation of plaintiff's son-in-law, the plaintiff executed the sale deed in a favor for which the plaintiff took consideration amount in presence of the registrar. She admitted that after paying the consideration amount, she was having possession of the land. The court also recorded that the plaintiff had claimed to have filed a criminal case, but no outcome of the case was produced before the court. court decided the issue number 5 against the plaintiff. And ultimately, held that, and also held in paragraph 7 that the plaintiff has failed to prove that the registered sale deed dated 7/1/2006 was executed by plaintiff in favor of defendant under misrepresentation, collusion, illegal, without consideration, and ultimately dismiss the suit. The learned First Appellate Court framed the 3 points for determination as follows in para 11. The learned court ultimately held that the plaintiff failed to prove that the sale deed in question was without consideration. Para 25. By deciding the second point for determination, the learned court held as under. Page 20, page 23, last part है para 27 का, 28 and 29. And ultimately the learned appellate court has dismissed the appeal by holding that a plaintiff has failed to prove the allegations, and that the sale deed was validly executed. This court finds that it was the plaintiff who was the karta of the family who had executed the sale deed in favor of the defendant for consideration, in favor of the defendant, and he himself challenged the same by stating that the sale deed was fraudulently executed and no consideration money passed. Both the courts have negated the finding, negated the plea of the plaintiff, and have held that the plaintiff failed to prove the allegation. The suit was not filed by any of the family members of the plaintiff, rather it was filed by the plaintiff himself. And admittedly he was the karta of the family. In such circumstances, this court is of the view that the learned courts have given concurrent findings on facts that the plaintiff had sold the property for consideration. The judgment relied upon by the Honorable Supreme Court or by the appellant asked by Honorable Supreme Court in the case of Vinita Sharma, paragraph 66, is of no use so far as the facts and circumstances of the present case is concerned. This appeal is accordingly dismissed.
Item 9, second appeal 179 of 2025.
This is my lord. The defendant second appeal against the judgment of the court. Suit was filed by the plaintiff lord, plaintiff number 1, under section 6 of the Specific Relief Act 1963, praying therein a decree lord for recovery of possession. Now lord, during the pendency of the suit, the plaintiff number 1 has sold the suit property to the plaintiff number 2 without seeking leave of the court. And thereafter, my lord, the plaintiff number 2 was impleaded as party plaintiff number 2 in the instant suit. Now, lordship may kindly see the findings of the learned trial court. The learned trial court, while decreeing the suit, my lord, came to a specific finding that section 6 of the Specific Relief Act is not applicable in this case. Even then, my lord, the suit filed by the plaintiff has been decreed. Lordship may kindly see page 32.
Yes, I will.
Lordship.
What about the appellate court?
Appellate court has held, my lord, that the appeal filed by the defendant is not maintainable in view of the provision contained in section 6, sub-rule 3 of the Specific Relief Act. This is the finding of the learned first appeal.
Although the trial court had
Lordship.
not given any such finding.
Lordship. So, my lord, both the courts have misconstrued, my lord, the provision contained in section 6 of the Specific Relief Act, and my lord may kindly see the plaintiff number 1 himself has stated, my lord, in his cross-examination that he is in possession of the suit property. Where is the question of recovery of possession?
You are the defendant?
Lordship.
You are the defendant?
Yes, I am the defendant, lordship. The defendants are bona fide purchasers of the suit property. They have purchased the suit property by virtue of registered sale deed. And if it, lordship, in view of the specific finding of the learned trial court that section 6 of the Specific Relief Act is not applicable, how will the suit have been decreed? And that finding has been affirmed by the learned first appellate court. Although the plaintiff did not choose to file any cross appeal against that finding, and he himself has admitted that he is in possession of the suit property.
What is the substantial question of law?
Lordship. Three and four.
See, 4 will be sufficient. So cross अपनी फाइल करने का क्या जरूरत है? Appellate court takes into care everything.
Four will be, sir.
Specifically fact. And from where do we get that the suit was filed under section 6 of the specific release? From where does the court say that the plaintiff was ousted from long settled possession over the suit plan on 13/5/2017? If there is any such finding that he was ousted from his long possession,
Then we look, this finding is perverse. And if this finding is perverse, my lord, the appeal filed by the defendant is well maintainable. There is no bar in filing appeal. Section 6 subsection 3 would not be applicable.
the learned counsel for the appellant has submitted that the courts have recorded inconsistent findings.
Lord,
He has submitted that the suit was filed for recovery of possession under section 6 of the specific relief act.
Lord.
And the learned court on the one hand held that the plaintiff was in possession of the property and also held that section 6 of the specific relief act was not applicable in the case. And further observed that it was admitted position that the plaintiff was ousted from his long settled possession over the suit land on 13/5/2017 by the defendant number 1 to 7, and the plaintiff was entitled for recovery of its vacant possession over the suit land. Submit that ultimately the suit was decreed in spite of holding that section 6 of the specific relief act is not applicable in the case. The first appellate court was of the view that appeal was not maintainable
Lord.
as in view of specific bar under section 6 of the specific
6 subsection 3, Lord.
6 within bracket 3 of the specific relief act itself. The learned counsel submits that once the trial court held that section 6 of the specific relief act was not applicable, 6.3 होगा सर, वो लगता है कि गलती से लिखा है।
6C में फाइल हुआ 6.3 में बोलता है कि बार
वो जो फाइंडिंग दिया है ना,
हाँ।
लगता है बार
6.3
the learned counsel has also submitted that even the plaintiff admitted in his evidence that PW1, no,
PW
who was examined as PW1,
PW
that he was in possession of the suit property
in para 44
in paragraph number 44. लिखा है? एक आइसोलेशन में थोड़ी हम लोग देखेंगे, उसके बाद लिखा है जबरदस्ती दखल कर लिया। Anyways, we'll frame it, we'll see that. The statement cannot be seen in isolation, the evidence has to be seen as a whole.
but we have both the courts have misconstrued the provision contained in section 6.
The learned counsel submits that both the courts have misconstrued the provision of section 6 of the specific relief act. This appeal is admitted for final hearing on the following substantial question of law. Roman 5. Issue notice to the respondents for which request under speed post be filed within a week, that the records be called for from the concerned.
By Friday. By Friday. And you know, there is one IM for stay of the further proceedings of execution case. Because you know, they are bent upon in taking daily beer. My lord may fix any dates.
IE may be noticed. We'll see that on the next. IE may be noticed. अगला डेट पे सुनेंगे सर।
जी, IE नंबर 1526 IE number
पोस्ट ऑन 18th March.
steps by Friday lord.
आपको जब तक मानो हम एक हफ्ता तक बाय फ्राइडे नहीं तो बाय मंडे।
Office.